Welcome back to the channel, and if you're someone who's been refreshing that Visa Bulletin page every month hoping for forward movement, or if you're an H-1B holder watching your wallet get lighter with every USCIS filing, today's video is absolutely critical for you. We're diving into two massive developments that could directly impact your immigration journey, your timeline, and yes, your bank account. Stick around because what's happening right now in November and December 2025 could change everything. Hey everyone! Before we jump into the deep end, if you're new here, this channel is all about breaking down complex immigration news into actionable insights that actually matter to your life. We cut through the legal jargon and government speak to give you the real story. So if that sounds valuable, go ahead and hit that subscribe button and ring the bell so you never miss an update that could affect your immigration status. Let's start with the Visa Bulletin situation because I know many of you have been on the edge of your seats waiting for any kind of movement. The November and December 2025 Visa Bulletins have landed, and I'll be straight with you, if you were hoping for significant forward progress, you might want to sit down for this. The dates are holding remarkably steady across most categories, and for those in the employment-based categories, particularly if you're from India or China, this steady state might feel like you're running on a treadmill that's going nowhere fast. Here's what's actually happening. The Department of State releases these bulletins monthly, and they essentially tell you when your priority date needs to be for your green card application to move forward. Think of it like a queue at your favorite restaurant. Your priority date is when you got your number, and the bulletin tells you which numbers they're currently serving. For November and December, they're basically calling the same numbers they were calling before, which means the line isn't moving much at all. For family-based immigration, we're seeing similar patterns. The F1 category for unmarried adult children of U.S. citizens is crawling forward at a snail's pace. If you're from Mexico or the Philippines in this category, you already know the wait times have been brutal, and unfortunately, these recent bulletins aren't bringing much relief. The F2A category, which covers spouses and minor children of green card holders, has typically been the fastest-moving family preference category. But even here, we're seeing dates that are barely budging. Now let's talk about employment-based categories because this is where things get really interesting and, frankly, frustrating for many of you. The EB2 category for advanced degree holders from India. You're looking at priority dates that are years behind where many of you need them to be. The EB3 category for skilled workers from India is in a similar boat. China is experiencing retrogression in certain categories as well, though not quite to the same extent as India. The sheer volume of applicants from these countries combined with the per-country caps creates this perfect storm of backlogs that just won't seem to break. What's driving this stagnation? Well, it's a combination of factors. First, there's the annual numerical limit on green cards. Congress sets these caps, and they haven't been adjusted in decades despite massive increases in demand. Second, there's the per-country limit, which means no single country can receive more than 7% of the total available green cards in any category. This sounds fair on paper, but when you have countries with huge populations and high numbers of skilled workers like India and China, that 7% cap creates these massive backlogs that can stretch into decades for some unfortunate applicants. There's also the issue of visa recapture and how unused visas from previous years aren't being utilized as efficiently as they could be. Various pieces of legislation have been proposed over the years to address these issues, from eliminating per-country caps to increasing overall numbers to allowing better recapture mechanisms. But as of right now, none of these have made it across the finish line in Congress. So what does this mean for you practically? If you're waiting for your priority date to become current, these steady bulletins mean your wait continues. If you're in the final interview stage and your date is already current, you're in a better position. But you still need to remain patient with processing times at consulates and USCIS offices, which have their own backlogs to deal with. If you're just starting your green card journey, especially if you're from India or China in the employment-based categories, you need to be prepared for what could be a very long wait, potentially measured in years or even decades depending on your category. One important thing to remember is that priority dates can occasionally move backward, something called retrogression. We haven't seen major retrogression in these bulletins, which is actually a small silver lining. At least dates aren't going backwards. They're just not going forward either. It's like being stuck in neutral rather than reverse, which is marginally better but still frustrating when you're trying to plan your life, buy a house, change jobs, or make other major life decisions that are all tied to your immigration status. Now, let's pivot to the second major issue that's creating waves in the immigration community, and this one involves money coming directly out of your pocket. There's a significant legal challenge brewing around H-1B fees, and here's the kicker. There's a December 8th deadline that you absolutely need to know about if you've paid certain H-1B fees recently. Here's the background. USCIS has been charging various fees for H-1B petitions, and some of these fees have increased substantially over the years. We're talking about the base filing fee, the American Competitiveness and Workforce Improvement Act fee, the Fraud Prevention and Detection fee, and for some employers, the Public Law 114-113 fee, which is significantly higher for companies with 50 or more employees where more than 50% of the workforce is on H-1B or L-1 status. The challenge that's been filed argues that certain fee increases, and the way USCIS has been calculating and implementing these fees may not be in accordance with the law. Without getting too deep into the legal weeds, the argument centers on whether USCIS followed proper procedures when setting these fees and whether the fees themselves are justified by the actual costs of processing these petitions. Now, here's where the December 8th date comes in, and this is crucial. If you or your employer paid H-1B fees during a specific time period, you may be eligible to join this challenge or file for a potential refund if the challenge is successful. The December 8th deadline is when certain actions need to be taken to preserve your rights in this matter. If you miss this deadline, you could potentially miss out on recovering fees that you shouldn't have had to pay in the first place. Let's talk numbers for a moment, because this isn't just about principle, it's about real money. Depending on your employer's size and characteristics, the total fees for an H-1B petition can run into thousands of dollars. For individual workers and smaller companies, these fees represent a significant financial burden. For larger companies filing hundreds or thousands of H-1B petitions, we're talking about hundreds of thousands or even millions of dollars in fees. If this challenge succeeds, the financial implications could be massive. What should you do about this? First and foremost, if you're on an H-1B visa or if you're an employer who's filed H-1B petitions, you need to document when you paid fees, how much you paid, and which fees you paid. Gather your receipt notices from USCIS. If your employer filed on your behalf, reach out to your HR department or immigration attorney to get copies of the fee receipts. You'll want this documentation ready if you need to take action. Second, and I cannot stress this enough, consult with a qualified immigration attorney before the December 8th deadline. Every case is different, and whether this challenge applies to you depends on specific factors like when your petition was filed, which fees were paid, and other individual circumstances. An attorney can review your situation and advise you on whether you should take any action before the deadline. Third, stay informed. This situation is evolving, and there may be updates, extensions, or changes to the process. Follow reliable immigration news sources, subscribe to updates from reputable immigration law firms, and yes, keep watching this channel because we'll be covering any major developments as they happen. It's worth noting that challenges to government fees aren't uncommon, but they're also not guaranteed to succeed. The government will undoubtedly defend its fee structure and the processes used to implement it. This could play out in courts for months or even years before there's a final resolution. However, the December 8th deadline is about preserving your right to participate in this challenge and potentially benefit from any favorable outcome, even if that outcome is far in the future. One broader point worth making here is that all of this, the stagnant Visa Bulletin and the fee challenges, highlights the broader dysfunction in our immigration system. We have a system that was designed decades ago for a different economy, a different workforce, and a different world. The caps haven't been updated. The processes are slower than ever. Fees keep increasing, and the people caught in the middle are families, workers, employers, and communities who are just trying to plan their futures. There have been numerous proposals to reform the system, from comprehensive immigration reform bills to more targeted fixes for employment-based immigration or family-based immigration. Some proposals would eliminate per-country caps. Others would increase the overall number significantly. Some would create new categories for entrepreneurs or STEM workers. But year after year, despite bipartisan acknowledgement that the system is broken, we see very little movement in actually fixing it. So where does this leave you? If you're waiting for your priority date, patience remains your main virtue, frustrating as that is. Keep your documents updated, maintain your status, and be ready to move quickly when your date does become current. Consider whether there might be other pathways available to you, whether that's through a different category, through a family member, or through other options your attorney might identify. If you're dealing with the H-1B fee situation, don't sleep on that December 8th deadline. Get your documentation together and talk to an attorney about whether taking action makes sense for your situation. Even if the outcome is uncertain, preserving your rights now means you'll have options later. And for everyone navigating this system, remember you're not alone. Millions of people are in similar situations, waiting, hoping, planning, and dealing with the uncertainty that comes with immigration processes. Stay connected with your community, share information, support each other, and advocate for the changes that need to happen to make this system work better for everyone. That's all for today's Immigration Alert. If you found this information valuable, please give this video a thumbs up. It really helps more people find this content when they need it. Share it with anyone you know who might be affected by these issues. Drop a comment below with your own experiences, your questions, or any other immigration topics you want us to cover. And of course, subscribe and hit that notification bell so you're always in the loop when major immigration news breaks. Remember, knowledge is power, especially when it comes to navigating immigration. Stay informed, stay prepared, and I'll see you in the next video.